Welcome to the Audio Socket podcast. We're currently exploring the impacts of AI on the music industry and how artists and creators will thrive in an AI era. Hi, welcome back. This is Jen with Audio Socket. If you've been part of this journey, then you know that we have been looking at equitable solutions for creators and IP owners in an AI era. And today we're going to be talking to Jacqueline Charlesworth. Jacqueline has a very prolific career in music and in law. She served as general counsel for the Harry Fox Agency, for the NMPA, the U.S. Copyright Office. She has her own private practice now in LA, focusing on music and film. And she's a guest lecturer at the Harvard Law School. So welcome, Jacqueline. Thank you for being here.
Oh, thanks so much for having me, Jen. There are lots to talk about in this area.
Yeah, it's funny. I mean, I think about just the things coming my way each day, and I genuinely feel like I could create a full-time job just keeping up with AI. So I imagine if you step back a year ago and it's November 9 of 2022, let's say you're looking at kind of projecting what 2023 is going to look like for your practice. Does it look anything like you thought it would in terms of the impact of AI?
No, I mean, I have to agree. It just kind of exploded. Although I am involved in a litigation which has some AI stuff going on that's been going on for several years. I mean, I think part of what happened here is, we have the research and the development of these tools have been going on, for quite a while, right? Many years, but it just suddenly emerged into the public sphere, into the, for where ordinary mortals and lawyers became aware of them. And it is amazing. I was in DC recently, and every time you sit down at a restaurant, all you can hear is the word AI all around you. So it's definitely very preoccupying. I think rightfully so. It's a huge sea change for creators and, in a lot of other fields as well, including law.
Yeah. So just kind of to start with the basics, would you mind talking about whether you feel like law is behind, I guess, on the AI scope of things? If it is, why? And is that the norm?
Well, the simple answer is yes. The law, I think, is really not remotely caught up. I mean, it's interesting, although there are some analogies to other technological changes, I do think there are some differences in the way AI works and kind of the whole framework that make it challenging from a legal perspective. But, there's two main sources of law, that govern sort of copyright and related issues. There's statutory law, which generally is made by Congress for copyright, of course. And then you have judicial decisions. And, we don't have either right now that specifically addresses AI. We have the Copyright Act, which has very important broad principles, which have generally stood the test of time very well. I mean, it's been updated over, since it was adopted a couple hundred years ago. But, it's flexible, which is great, but it doesn't really specifically tackle, generative AI or training models. And so I think that's what we're all kind of very focused on right now is what's the path forward. Congress generally takes a long time to legislate. There's a lot of disagreement here too, which doesn't help to move legislation forward in terms of, you have the tech platform saying, oh, it's fair use. And you have creators and, others saying, no, you're taking my stuff. So that is not an easy blueprint for Congress to move forward. And so I think a lot of creators and owners of content have turned to the courts looking for judicial guidance. And those, we have a number of class actions pending, as you've probably heard. It is a long list now and a growing list, but we're still early days in those cases. And even those efforts are going to take some years probably to play out before we get actual answers from judges, if they're assuming the judges are willing to give them. So it's a time of tremendous sort of change and, waiting to see how things play out.
Yeah. Again, kind of speaking to people who aren't attorneys and don't necessarily hang out with a lot of attorneys, what is that process going to look like, and what do you see as the timelines for us to really have some laws shaped and formed? Is that just all these lawsuits that are currently happening that's going to establish some case law prior to when there's more congressional legislation? If you can just tell us how you see that unfolding and potentially. Obviously, it's a moving target, but when that might be possible.
Yeah. So, well, one thing I haven't mentioned yet is, President Biden issued just recently an executive order on AI, very comprehensive. I mean, I sat down to read it and I thought, oh, this will take a few minutes. It's very long. Every executive agency is, I think, been called to examine how AI impacts their area. And so I think that is kind of the focus, at the highest levels of government is going to help push the conversations along. That said, in the context of AI, I mean, even just figuring out like little corners of this and how to balance the competing interests and address changing technology that's still evolving, it's going to be tricky. I think that as I said, copyright issues and copying and use of expressive works is a big area of concern. Another area, particularly in music, is the use of artist persona, their voice, their likeness, the fake Drake syndrome. And that's really falls under a different area of law called right of publicity, which is generally covered under state law. I mean, there's a little federal law that relates, but I think, there's some interest now in creating a uniform federal system to deal with those issues, particularly since we have all these AI, the impersonation and so forth. So I think that may, in some sense, seems to be slightly ahead of the copyright discussion in terms of the way Congress is thinking about this, but it's still really early days. And my prediction is, it could take years before, assuming Congress decides to act, before we see anything from Congress. The courts, most of these cases are class actions. And then what a class action is, you'll have a few named, say, artists or musicians or copyright owners suing on behalf of a whole class of other people who are similarly situated. And those cases tend to be more complicated because in addition to the actual issues of copying and using the works, you also have a lot of fighting and skirmishing about whether the class is properly defined and whether the plaintiffs that have been chosen actually represent the class and what the particular works are that you're going to look at to decide whether this was legal or illegal. And so those cases too, I think, are going to take years. There are a couple of cases that are a little ahead in terms of, judicial decisions where we're seeing a little bit of, we're seeing early decisions coming out. One is the Anderson case in the Northern District, which involves visual art. Northern District, California, where we have an early ruling where the judge there decided that one claim, which is very strong, which is sort of the copying of all these works to train AI models, could stand, but a lot of the other claims in the lawsuit have been dismissed with a leave to replead them or represent them in a more detailed form if the plaintiffs can do it. So, that's an example of, we're very early stages. We're still trying to figure out what the claims are that are going to be litigated in that case. So I think, in the meantime, and we'll probably talk about this, the question is, what can be done without relying right now yet on legislation or the legislative process or the judicial process, which, even again, when you get a decision from a district court, it gets appealed potentially all the way up to the Supreme Court. Years. We're looking at years.
Yeah. Yeah. So, I mean, I've been thinking a lot about that as far as creators go and just what is the right kind of protective mechanism for them. In my opinion, I sort of think by publicly making your either permissions or lack thereof known, it's a bit of a de facto, leveraging the laws that exist today. But what would you say creators can do today to best protect themselves from being leveraged in the meantime?
Yeah, well, I think, it's interesting. I think we're starting to see maybe some technological tools to opt out or, do not crawl. So if you're posting stuff on, I mean, the big issue is if you're posting stuff online, you have to assume it's going to be crawled and sucked into these models. So if you have things, that you do not want that to happen to, you either need to not put them online or put them online in a protected way. I don't know, Jen, if you've seen it, but there's something called Nightshade and Glaze for visual arts, which are actually technological tools that allegedly change the pixels of what you're posting and kind of mess up the AI bots. So, I am not necessarily recommending that, but it's interesting that we're starting to see tools on the other side of the equation to help protect art. I'm not aware of any yet in music, but that's an interesting question for me, is whether there'll be technological things that can be done to protect musical works and lyrics and so forth online. But, the biggest push, I think, or the biggest hope, frankly, for creators is probably to figure out ways to license, if they choose to license, the material for training. And so there's a lot of effort, I think, in different industry sectors, not just music, to look at models, collective licensing models. You can't do it unless you're a big artist. Big artists would probably have, the ability to do a one-on-one deal with, open it or whatever, whoever wants to use their stuff. But, for smaller creators, I think we really need to look to collective licensing models, hopefully, and creating and making sure that market is intact. And, on the receiving side, if you're trying to train a generative AI model, having curated high quality content is also important, not to mention the fact that you're reducing your risk of being sued. So I think that's where a lot of the focus is right now. If you're in the music space, I would say just, trying to stay abreast of this and keeping track of the, licensing efforts and so forth would make a lot of sense. And also advocating for that. I mean, this is, I think it probably goes without saying, when you have, large platforms or models just sweeping all of your stuff in to create new stuff that competes with your stuff. I mean, that's a tremendous transfer of, in my opinion, value and wealth to those platforms who are taking it and claiming they can do that without payment. And I hope that we're going to get to a place where there's a more balanced view. And I know there are some AI companies out there that at least are interested in licensing stuff and can kind of help set the bar or the kind of tone of what we're going to be looking at going forward if you're using the creative works to train your models.
Yeah. We're actually revising our artist agreement right now to specifically address AI and our positioning on it. For generative AI, we're not doing anything with that at this moment, but we will permit training capacities depending on what that model looks like. So I actually had a call with somebody today, and what was encouraging is that they specifically said, are you interested in doing a licensing deal with us where we would use your music to train, and it's actually for a protected purpose, like you were talking about, which is very definitely in our best interest. But then on top of that, they talked about the back end side too, and that's most certainly the way that I would like to see things going, which is if you're using this intellectual property to train, then it's great if we can be part of a long-term revenue stream, and certainly we're advocating for that on our end. But
yeah.
And it reminds me.
I was just going to say, you make an important point, which is the contractual level. Like if you're an individual artist and you're working with a company like yours, Jen, or making sure you're understanding what rights you're keeping and what rights you're giving up. And sometimes that requires the help of a lawyer, sometimes not. But like all these, traditional contracts just don't deal with these uses. So very good point, Jen, to pay attention to the fine print.
Yeah. And I am seeing a lot of companies doing that now. In fact, I'm party to a number of companies that have sent out policies as far as AI goes. This is what we're doing. Here's things that we are participating in. Here's things you would have to opt into. So at least from our perspective, I think from this creator industry perspective, it is being conscientious of its peers. So now hopefully we'll see that with the tech companies too. Obviously what is done, and that's a little too late for, looking backwards, and that's where case law will be established. But I think looking forwards, I'm feeling hopeful about what people are working on. So I'd love to talk about the U.S. Copyright Office study, because I'm sure that you've been following it closely. Mm-hmm. And I have a general understanding of really its purpose and sort of the things that it's looking at. But can you explain what that study is intended to do and some of the questions that it seeks to ask?
Yeah, no, for sure. So the Copyright Office, I don't know if you've heard in an earlier part of this series, but they're conducting a very broad study on AI and the impact on copyright law. And there are many questions have been asked, and I think they've received close to 10,000 comments as of today. Wow. That's quite a lot. I've read them all. No, I have not. But it's because I worked in the office and oversaw. I remember we had a DMCA study where we got thousands of comments. Believe me, people will be reading them and reviewing comments. And the study is very important. And I mentioned the Biden executive order. In the executive order, Biden says, and the copyright. We have to look at what the Copyright Office is saying as part of what the executive branch is going to be developing in terms of AI policy. So it's kind of part of that whole overview and consideration of how things should move forward. And the two specific topics are the use of works for training purposes, and also the protection of works, which we haven't really talked about much. And really is very pertinent to music, because I think in music, you're going to have people who are relying on AI tools to some extent, or maybe inspired by or whatnot. And right now, the policy of the Copyright Office is it will not register a pure AI work. And we've actually even had a judicial decision upholding that. The law has been interpreted by the Copyright Office in the court now as saying you have to have human authorship, meaning the human is controlling, and just having putting in prompts and having stuff fed back to you. Those things that are fed back to you, the output is not, if it's purely generated by AI, is not protectable. And there's some amount of debate about this because people are investing in AI tools and artists use AI tools. The Copyright Office will register what I call a hybrid work, where if you have some human authorship, let's say you had a song, you contributed most of the music, but you use a chatbot to come up with some of the lyrics. There's a way to register that, and where you just you disclaim, it's called the lyrics or the part that's AI generated, but the rest of the work as a whole you can register. And I think that's important for people who are using these tools to realize that they can go ahead and register it. But that question of, should we be protecting AI works? Maybe it shouldn't be copyright, maybe it should be some kind of sui generis kind of protection. That is also on the to-do list here. We see, the major players, the music publishers, the record labels, the ASCAP have all filed extensive comments. A lot of them focus on the fair use issue, which is, I think, probably in terms of the legal piece right now, the biggest sort of issue that a court can or would decide in one of these lawsuits, potentially affecting, other classes of works. That's
I saw an article today about Anthropic and their defense in terms of they're using fair use as sort of their defense on their positioning. Is that something you've read? Are you familiar?
Oh, yeah. No, this is really the legal battleground is about fair use. And, for those of you who follow copyright at all, you might remember there was, when Google copied millions of books, there was a big judicial decision that said because they weren't actually letting you read the books, you just could see little snippets, that was a fair use of, they were allowed to do that without permission. And so on the people who are arguing for fair use kind of love that decision and, some other cases. I think on the other side, you have the recent Warhol case, which is another very interesting fair use decision, just came down from the Supreme Court that kind of looked at the parameters and kind of tightened up, I think, the parameters of fair use, and what is called a transformative work, which I don't want to get too into the weeds, but the bottom line is this question of whether you can copy masses of works without permission and whether there's some excuse for that in the law, which is what fair use is a huge looming question. I think it's important. I hope that courts will understand that the AI tools, that sort of copy stuff, use the stuff to train the models, and then but the images or music or whatever it is they're using isn't retained in its full form in the models. This is something that really has not been addressed in any fair use decision before, and I hope that courts realize that it's not really the same as Google, for example, because Google did copy the whole books and retain them but didn't let people see them. This is a little different, where you have algorithmic representations of the works that are retained. And in the Anthropic case, which you just mentioned, which is a case involving lyrics, the models are able to spit out basically the same lyrics that they absorbed in the first place. So, if you query, and this is true of a lot of these models, if you query it in the right way and say, I want the lyrics to song X, the information it has stored is sufficient to basically regenerate the lyrics. And clearly in a, they look, it's a copy, almost an exact copy or substantially similar. And that is a big problem. And I think that is challenging to say that's not copying or that's fair use. So I think, courts are going to have to hopefully really think carefully about the differences between AI and what's come before, because it really is not the same, not the same as what we've seen before in fair use cases.
Yeah. We had an earlier interview where Cliff Fluette was on with us, and he was saying that he thinks AI is like electricity or steam. It's literally going to change and turn everything on its head. And with that, there's going to be a lot of really important decisions as far as how much does human creativity thrive, and a lot of that is going to have to do with what we're looking at, which is long-term equitable solutions that promote that sort of thing. So very important stuff right now. There is a New York Times article that somebody just forwarded to me yesterday, and it cites Biden's executive order, and it says, are we making too much progress and also too little? And they look at social media and, just the idea that perhaps we didn't regulate it quick enough, didn't do enough. So, we need to be looking out for all of the potential pitfalls. But in doing so, are we going to throw so much regulation in there that we effectively create a monopoly, that it's so prohibitive that newcomers can't come to the table and innovate? So it was a really interesting article that really just sort of looks at the challenge of, I think, lawmakers. It looks at the challenge of people that are deciding on regulation, and how far do we go into the hypothetical versus how much do we really try to work with what we have today. So,
it's interesting. I mean, the issue of market dominance, I was going to mention this, you have some of the larger companies offering to indemnify their customers, like OpenAI, and I think Google has offered. That is a very, in some ways, troubling prospect. It's basically money, money can buy you out of the liability. And we saw that. That was also a concern actually in the Google Books case, that Google, they were sued and they entered into a prospective settlement, which would have given them basically the absolutely dominant position in the industry. And, the Justice Department came in and said, well, that's not so good, that we can't benefit Google and not let competitors in. So I think that is a concern, for sure, that the dominant platforms who are so far ahead and have so much more money. This is, and I will say, there's social media and just in general, internet use in the internet, the tape now, pay later model does not generally help creators much. because, if you're not setting the terms of the license, if someone takes your stuff and then you're there saying you're begging for the scraps on the table potentially. And I think that's how a lot of creators felt in the, say 2010s, or, the era, certainly around the DMCA and the takedown process and so forth. It's like, the leverage is shifted. So you're just saying, please pay me something, and, take a license and pay me something. And they already have all this stuff. And that's a tough position. And it's particularly tough if you have an extremely wealthy, platform with all the resources, legal and otherwise, to try and push back. So I think when I read the article too, I very much, that resonated with me, that I think that we did, I think things got a little out of balance. Let's just put it that way in the last go round, but it was not nearly as revolutionary as what we're going to see with AI. And so I think there's even more risk here, that we're going to be sort of, there'll be 2 or 3 companies, and I don't mean to sound like sort of apocalyptic, but, that really have a lot of resources and enormous power, whether it's through social media, through having all the expressive content, et cetera. It's something to really think about on a deep level as a society, whether that's really the way we want to be living. But that goes way beyond copyright. So I'm sorry starting to stray into the deeper ethical and sort of social issues here. But I do see this as a major, just complete change and potential change in the way we live generally.
Yeah. What's interesting is you and I met at the copyright roundtable sessions about a decade ago. And I doubt you remember this, but I wrote a kind of my takeaways. And I sort of built a little kind of what's needed is TTC, and which is transparency, trackability, and collaboration. And kind of I outlined that in this article. But, the premise of it was that creators often end up sort of having solutions built for them by the people that they sued. And those are imperfect solutions. And it really is that prompt that led to this series. It's kind of the idea that creators are often late to the table as it relates to disruption innovation. Now, granted, innovation drives creators to proliferate, do more, expands their reach, et cetera. But oftentimes, I think the way that I positioned it was technologies are born out of lawsuits. And I'm hoping with this series and just obviously a lot of creators and IP owners and companies that own IP, that they will be very proactive in coming to the table to build and establish those licensing models. Because when things are very difficult, I think that is when we see people start to take. So I think we could actually be at the forefront of this conversation and actually set terms and begin to control narratives. There is where I think we win, is proactively as opposed to defensively. So
Right. Yeah. Lessons learned in the Napster era, I think.
Indeed.
I think that was I agree, which is why I said, I agree wholeheartedly that creators and, all the different sectors should be looking at licensing models, because there is, the leverage here is that there is legal risk that these companies will be sued, and they're going to, which is, even though they have more money, it's expensive for them and the outcome is uncertain. So trying to establish a framework for this now in a voluntary way, cooperative way, I think is our best way forward.
Yeah. So more on a less legally specific, but on a generic level, what would you, if you have I'm sure you have creators that are clients, what sort of advice are you giving them? Like, what are the risks and opportunities you're seeing, and how would you be advising them just to take cautious steps in this AI era, but also proactive steps?
Well, as I said, I think, I have different kinds of clients. Some of them are organizations that are, of creators, and they're, as I mentioned now a couple times, the question is, can we come up with a licensing model and how to implement that? And I have a lot of background in that because I was very involved in the Music Modernization Act, music, the 115 license for years. So that's very familiar territory, although it's still brand new for a lot of industries to think about that kind of collective licensing. I think on an individual level, as I said, it's really being very aware of, if you're signing a record deal, are you giving up your right of publicity or your forever to a record label? Is that something you want to do? Do you want people to be able to use your voice and likeness, or do you not want that? And how do you try to implement that? I think, fortunately, and I think the record labels have, through the relationships with various licensees and the big platforms, actually have been somewhat successful in kind of trying to set some boundaries around that, and through private negotiations. I'm not privy to them, but just from my understanding is that, where there's a commercial relationship and there's a desire for the content and the material, then hopefully the parties can kind of get together and work on that. But an individual creator needs to pay attention to what rights are they signing away if they're signing with a record label, publisher, or So I think those are the sorts of things that creators should be paying attention to at this point. And in addition to I think on the registration side, I talked about that briefly. If you're making these works, making sure that you're registering them properly with the Copyright Office, if you want to register them, and and that you're doing things by the book so that the registration will stand up later in court if something happens. So that's another important piece of this, and definitely a sub-dialogue that's very active right now is the registration process.
Yeah. Do you think that it's going to take a lot of give across all sides to get where we need to? And partially I'm referring back to, like we were talking about, the Napster days. I think the music industry has found a hard time kind of coming together to agree, which obviously delays things holistically, but also to find ways to make things like licensing less complex. Do you see that there's really going to need to be a willingness, I guess, to let go of some of the control in order to find a way to proliferate in this AI era versus just a whole bunch of lawsuits that are ongoing forever?
Yeah. I think there are some of the platforms that are seeking to use the, content are probably a little bit more open-minded and flexible in the way they're thinking about licensing programs. And then some seem to have drawn a line in the sand. When I read, I think you sent me the article, the Anthropic article, where they're saying it's fair use. Well, come on. I'm sorry. Taking people's lyrics and then building a machine that spits them out again. That's a tough fight. It just is obviously I love creators. I'm, very sensitive, but it's like, does that feel fair? I don't really, yet there is a piece of the sort of narrative going on, if you want to call it that, or the debate going on, where some of the companies and platforms have just taken this really bright line position that this is fair use, it's training, and therefore anything is fair game to be taken from the internet. That is concerning to me, because that to me is not suggestive of the kind of thinking that you referred to, that we need a more flexible mindset to come together on both sides in terms of how to solve this problem. I think the mechanics of how to set up licensing organizations, that we already have a lot of collective licensing that goes on, whether it's in music or, with technologies that know how to, you can take in information and send out royalties. And, it's not so much a technical problem, it's a conceptual problem, and trying to get both sides at the table to agree to a fair way to compensate creators.
Yeah. So one final question for you. When you think about AI, clearly it's here to stay. It's going to be a bigger and bigger and bigger part of our worlds by the day at this point. Do you feel hopeful and optimistic? Do you feel cautiously optimistic? Do you feel concerned? And, I always ask this of creators too. And I'm surprised actually a lot of the time at the answer, but yeah, I'd love your thoughts.
I think it's hard not to be somewhat concerned. And my concerns are definitely, you've heard what I've said. I mean, I'm concerned about creators and human creativity. I mean, for me, and I think I'm a copyright lawyer because I really wanted to be a creator, and you know what I'm saying? Like, I love human creativity. To me, that's part of what makes life worth living. So, like, this idea that we're going to live in a world where people, you know, that's not highly valued, is troubling to me. But, you know, the implications of AI go way beyond that. I mean, there's issues with, you know, national security, and, you know, I don't know, there's positives, there's scientific, you know, it seems like it will help make scientific advances and medical advances. That to me seems really good. But some of the, you know, the ability to, you know, manipulate social media and other things seem very frightening. You know, I thought that the Biden order, I was, as I said, I was impressed by it, partly because it shows that there is focus on this and understanding. And I know, you know, so that gives me some hope. But I mean, to me, this is a a challenge on the level of like climate change, because it's also going to require global cooperation, and it's tough. I mean, hopefully my concerns are a little overstated, but it seems we're going to be, as I said earlier, living in a very different world in 10 years. And, you know, hopefully, you know, humanity will prevail, won't be run by robots.
There have to be enough people with concern to make sure to balance it all out, right? So, Jacqueline, when you think about global impact and similar issues like this across history, can you think of any situations where, on a global scale, where this disruption was happening and parties on both sides of the table did come together to really compromise and there was a good outcome?
Well, you know, I mean, I would liken this. I mean, we have copyright treaties, of course, which are very important and help. And although copyright isn't standard around the world, they help to, you know, basically create reciprocal rights and obligations. And so that framework, you know, if you're thinking about copyright, is helpful. But, you know, I think the issues really, as I said, here are bigger than, as much as I care about copyright and rights of publicity and creators, that, you know, they transcend those issues. I mean, they get into issues of national security and so forth. So, I mean, we're talking, I think, you know, the level of, you know, treaties, you know, that are involved, like the use of AI and, I don't know, military contexts or other, you know, I mean, there's quite a bit to be thought about here. And the issues of, you know, national security and so forth, as I said, I think are part of what's driving the urgency, the sense of urgency in Washington. I mean, we're focused on one piece of this, but in a way that's a good thing, because it's making people think generally about the issue. But you've seen, I mean, climate change is a good analogy, I think, where you have sort of almost, well, that is an existential threat to humanity. And, you know, we've seen some steps forward and some steps not so great steps in the global, you know, that's how I sort of envision those sorts of conversations going around the globe, because I think there's incentive for other countries to kind of, there's a bit of an arms race going on in terms of who develops the technology the fastest. And, you know, that's something that really needs to be taken into consideration as part of the overall kind of global picture.
Yeah, definitely. Thank you for joining us for this episode of the Audio Socket podcast. Stay tuned for more episodes and more guest speakers.